This is Michael Popok, and you've reached a special edition of Judge Luttig After Dark on Legal AF. What is a tautology? Why is Chief Justice Roberts all hot and bothered about it? Is he right about the decision by the D.C. Court of Appeals in the one time that anyone in 2.5 hours during the immunity oral argument even mentioned the decision below? For a court that's supposed to be reviewing the decision below? What does it all mean? Why does it matter? Judge Luttig has his strong opinions, and I discuss it with him during our interview and what it means for the eventual decision about whether Donald Trump is going to skate away from criminal liability for what he did on Jan 6 and leading up to Jan 6 and the cling to power. Let's take a listen to the interview.
Let me play a clip from, thank you, Judge. Let me play a clip from Chief Justice Roberts. And the more I listen to the clip, the more I realize that the actual only issue on appeal, it's obviously framed by Roberts because you can hear him use it in the way he's debating with Mr. Dreeben, the lower court's decision. It was the only time I heard in 2.5 hours that the lower court decision, which was supposed to be the decision that was being reviewed on appeal, was even mentioned, which goes to your point that they didn't seem to be concerned about the fundamental issues they should be deciding, but they came in with some preconceived notions and making, as you termed it, argument from the bench. Let's play Chief Justice Roberts in his discussion with Dreeben about the tautology that he found that he was troubled by in the District Court of Appeals decision.
Because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Do you agree with that statement?
Well, I think it sounds tautologically true, but I want to underscore that the obligation of a president is to take care that the laws are faithfully executed.
Well, I think it sounds tautologically true as well, and that, I think, is the clearest statement of the court's holding, which is why it concerns me. As I read it, it says simply, a former president can be prosecuted because he's being prosecuted.
Well, I would not suggest that that's either the proper approach in this case or certainly not the government's approach. A prosecution does, of course, invoke federal criminal law. The allegations have to be presented to a grand jury, which votes upon the indictment.
Well, that's what I mean, shortly after that statement in the court, that court's opinion, that's what they said. But there's no reason to worry because the prosecutor will act in good faith, and there's no reason to worry because a grand jury will have returned the indictment. Now, you know how easy it is in many cases for a prosecutor to get a grand jury to bring an indictment, and reliance on the good faith of the prosecutor may not be enough in the some cases. I'm not suggesting here. So if it's tautological, and those are the only protections that the Court of Appeals below gave, and that is no longer your position, you're not defending that position, why shouldn't we either send it back to the Court of Appeals or issue an opinion making clear that that's not?
I just heard a Chief Justice of the United States Supreme Court in a hypothetical assume a lawless grand jury, a lawless Department of Justice, a lawless Attorney General, and by extension, a lawless judge in order to make his point. It was troubling to me. What did you make of Roberts and his back and forth with Mr. Dreeben?
Well, Michael, it was one of the most regrettable exchanges of the many regrettable exchanges that day. But the statement that the Chief Justice read from the D.C. Circuit's opinion was not tautological at all. And anyone who even, understands what a tautology is would have understood that the statement was not tautological. What the statement said, in effect, if not exactly, was that only that the indictment alleges that the former president violated the law. That itself rendered the statement not tautological in any sense whatsoever. So, Mr. Dreeben, who's one of the most gifted advocates before the Supreme Court in this generation, I think that he was probably, knocked back on his heels by the tautological suggestion by the Chief Justice, and all but said that he thought it was tautological also, but it was not. Most fundamentally, though, the Chief Justice did emphatically say that's what the circuit court said, and just as emphatically, that is not the holding nor the reasoning of the D.C. Circuit.
Yeah, you're in trouble when the Chief Justice is summarizing the opinion below wrongly. And you're off on the wrong foot, and they're trying to do something else here. So I read in preparing for today, I read some of the things that you've read and said leading into this, and I pulled a couple of clips to have you respond to them when the discussion turned to pardons. The power of the pardon. Ketanji Brown Jackson, in a clip that we played earlier, actually raised it first when she said in that same sequence, she said, if presidents don't face criminal prosecution or shouldn't face criminal prosecution, then what was the Ford pardon of Nixon all about? What was that about? And then we were off talking about pardons, which was picked up later on by both Kavanaugh and Gorsuch. Let's play the back-to-back here of these comments and let Judge Luttig respond. So let's have Kavanaugh and then the Gorsuch back-to-back.
How about, I think it came up before, President Ford's pardon. Very controversial in the moment.
Yes.
Hugely unpopular, probably why he lost in '76.
Yes.
Now looked upon as one of the better decisions in presidential history, I think, by most people. If he's thinking about, well, if I grant this pardon to Richard Nixon, could I be investigated myself for obstruction of justice on the theory that I'm interfering with the investigation of Richard Nixon?
So this would fall into that small core area that I mentioned to Justice Kagan and Justice Gorsuch of presidential responsibilities that Congress cannot regulate.
How about President Obama's drone strikes?
So the Office of Legal Counsel looked at this very carefully and determined that, number one, the federal murder statute does apply to the executive branch. The president wasn't personally carrying out the strike, but the aiding and abetting laws are broad. And it determined that a public authority exception that's built into statutes and that applied particularly to the murder statute because it talks about unlawful killing did not apply to the drone strike. So this is actually the way that the system should function. The Department of Justice takes criminal law very seriously. It runs it through the analysis very carefully with established principles. It documents them, it explains them, and then the president can go forward in accordance with it. And there is no risk of prosecution for that course of activity.
And perhaps if he feels he has to, he'll pardon himself every 4 years from now on.
But that, as the court pointed out, wouldn't provide the security because the legality of that is something that's never been addressed.
See, I want to live in the world of Mr. Dreeben. I want to live in the world where an office of White House counsel analyzes issues, even if they involve a president, to determine if there was criminality, decides whether to prosecute. I like that world. The world that scares the crap out of me and of our listeners and followers is the world that's being proposed by Kavanaugh, Gorsuch, Roberts, Alito, and I assume Thomas, although I was surprised he was on the bench for this one, but he was there, which is, in using examples from Justice Sotomayor, Kagan, and Ketanji Brown Jackson, a person in the office could use a military coup to stay in power and not be prosecuted, could try to assassinate a political rival, and it depends on the context, according to Mr. Sauer, and the like, and instead contrasted with people like Gorsuch, who turn the actual facts of January 6th and the attack on our Capitol into a peaceful, flower-presenting protest by a counterculture movement led by a peace-loving president as the example of what happened on January 6th, because they don't want to get mired into the facts of the indictment. What did you make of this discussion of pardons, self-pardons, and the like?
Well, Michael, I felt that I was in Alice's Wonderland, frankly. The clear suggestion by Justice Gorsuch, I believe, what was that this former president, who has been charged with these crimes against the United States, ought not to be tried for them because he did not have fair opportunity to understand that what he had done constituted a crime under the Constitution of the United States, and therefore didn't have the opportunity to pardon himself in advance. That was the import of that suggestion by Justice Gorsuch. That led then, of course, to the digression that unfortunately, or fortunately, depending on the viewer, the court had never had the opportunity to address the question of self-pardon. As I think you know, I actually did address it for the first time publicly that I'm aware 2 or 3 years ago, when it was rumored that the former president had pardoned himself secretly. And I wrote an op-ed or essay in the Washington Post reasoning through the limited authority, but most importantly, the pardon clause. And I concluded that a president does not have the power to pardon himself or herself, and that indeed the framers of our Constitution would have considered that obstruction of justice, rather than a manifest act of justice. But in any event, you couple that pardon discussion with the other discussion that was driven by Justice Alito to the effect that it would be we would enter into an endless cycle of democratic peril, if you will, were the Supreme Court to hold that the former president is not immune. The reasoning of that argument was that all future presidents of the United States of America, Michael, would corruptly and politically prosecute their predecessors for any and all acts, whether or not criminal in nature. The suggestion is deeply concerning for many reasons, not least of which it assumed, the argument assumed, that the prosecution of the former president is politically corrupt, and it sought a rule that would prevent all future presidents from politically and corruptly prosecuting their predecessors. And talk about something that's antithetical to America, to our Constitution, and to American government. That presumption is about as antithetical as I've ever heard.
Welcome back. That was Judge Luttig. He appears with us regularly. We interview him. We get down to constitutional issues the only way that we know how, by bringing on experts in the field. This case, conservative, federalist, former judge, who's got a thing or two to say about Donald Trump and the majority of the United States Supreme Court. If you like what we do here, join us regularly on Wednesdays and Saturdays at 8 p.m. Eastern Time on a little podcast we like to call Legal AF. Yep, it's exactly what you think. We'll tell you what it means when you join the show. We do that Wednesdays and Saturdays, 8 p.m. Eastern Time, and then on audio podcast platforms of your choice. And then I do hot takes like this one, a variation on them, about every day, if not every hour, on the MeidasTouch Network. And you can find my body of work, Michael Popok, over on this YouTube channel. Go over to playlists and contributors and find my name. You'll find my entire body of work, over 1,000 hot takes, just like this one. And then on top of that, you can, as I said, follow us, audio podcast platform, video podcast platform, and you can subscribe to the MeidasTouch YouTube channel and help them get to 3 million free subscribers before the November election. So until my next hot take, my next interview, my next Legal AF, this is Michael Popok reporting.
Heary, heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.